Well, today we're talking with the ex-trooper, attorney Randall Inniss at the Inniss firm in New York. And how you doing this morning, Randy?
I'm doing great. How you doing, Steve?
Oh, I'm good. I'm good. Well, I got a bunch of questions for you, so why don't we just go ahead and get into it? You're primarily DWI defense in New York. What would you describe the geography? I know you're just north of the Bronx. It's not Westchester County, is it? It's
Actually, it is.
oh, it is. It is Westchester County. Okay.
Westchester does incorporate the Hudson Valley. I'm actually in what's known as the Hudson Valley region, and that incorporates several counties: Westchester, Orange, Dutchess, Hudson, Ulster, Sullivan, Columbia, Green. I practice in about 7 or 8 counties. I do go beyond that at times, depending on the case. But yes, you're actually correct. Westchester is part of the area that I practice in, which is just north of the 5 New York City boroughs.
Okay. All right. Well, let's get into some of the specifics. Let's say I get pulled over. The police officer suspects me of driving while intoxicated. Do I have to take the field sobriety test?
And that's a great question. You talk about getting pulled over by the police officer. As a former trooper, I've pulled over, my God, hundreds, if not thousands. But the short answer to your question is no. You do not in New York State, and probably other states as well, if not all of them. You do not have to perform the standardized field sobriety test when it has to do so by a police officer. Again, there are some potential consequences for not doing that. Though they're not a citation, you won't receive a traffic infraction or traffic ticket for not doing them. Undoubtedly, the officer will denote, as they're taking notes, that you did not, and they will characterize you as being uncooperative. I suggest to people, if you're not going to take them, and if you fundamentally even decide to speak with an officer, because you do have a right to remain silent. Just explain why, whether you have a bad hip or a bad knee or, based on your weight or your age or some other factor, just so, with many of the agencies locally, not all, but with many of them, they report things and there'll be an explanation potentially on reporting for why you do it. And your demeanor will not necessarily come across as uncooperative, particularly if you provide an explanation for why you're not taking it. But again, importantly, there's no citation, there's no traffic ticket issue for you not taking. The legislature in New York State has contemplated this, and there's no overt penalty other than the officer possibly advising that you were uncooperative in his notes. So that aspect may later.
If I want to remain silent, do I have to invoke my Fifth Amendment privilege to do so?
You don't have to formally state that, that I'm, very, upfront. I'm invoking my constitutional right to it. I mean, you don't have to, but, you might point out that, that you invoking your right to remain silent. If you have an attorney, or an attorney inform you to do that, or whatever case. Again, this is the type of thing that sort of a yin and a yang to all of this. What happens with police officers is they will ask you, typically when traffic stop, a series of questions that are designed to elicit an incriminating response. So they say, do you have any idea why I pulled you over today? they're hoping that you might say something that's incriminating. I was speeding, right? You say something like that, it might be, well, how fast do you think you were going? Really? And then when you respond with something, it's typically a response that's over the posted speed limit. So you're providing this officer with an admission. So while you believe that you're being cooperative, that you like police officers, and that you're complying with their request, you are in fact providing them with ammunition against you. And you should not forget that. Exactly what they are doing. That's what you're trained to do. That's what police officers do. And so when they leave that encounter with you, they have a series of notes from you that are typically against your interests, that may serve as an admission, or sometimes, depending on the circumstances, even a confession in what they believe that you've done. So you don't formally have to say I'm invoking my right, but the more you speak in response to their question, the questions are designed, as I said, to elicit an incriminating response. Typically with a traffic stop, you are not in custody, so they don't have to read you your rights at that point. You're just being detained, so they don't have to read you your Randall. So the less you say, the better. Particularly in a stop where they may perceive that you're impaired. By speaking at all, you may be providing them with more ammunition in terms of them detecting or smelling the odor of an alcoholic beverage. So be mindful of it. Sure.
So if the police officer asks me to get out of the car, do I have to do that?
Well, yeah, that's another great question. I get that a lot. The short answer is yes. In New York, actually most states, but I'm admitted in New York State, and so everything I say is, again, it's for educational purposes and not legal advice. But yes, you do have to get out of the vehicle when asked by a police officer. The Supreme Court has looked over this so many years ago. It's a case called Pennsylvania. We don't need to get that technical, but in essence, what it ruled is the minor inconvenience of asking the motorist to step out of a vehicle or out of a car is far greatly outweighed by considerations of officer safety. So it's a minor inconvenience to you to have to step out when the officer requests you, but the officer's doing it in many instances for officer safety purposes. The officer is not going to tell you, necessarily that you made some furtive movement or why they're asking you to step out, and they're not particularly obligated to do so at that point. It could be a court hearing about that later on, but the side of the road with cars whizzing by or whatever, that's not the forum. But yes, you typically do have to exit the vehicle when asked to do so by a police officer. Now,
Is there any kind of testing at the police station? Is there a breathalyzer test? What happens there? And then do I have to do that test? Two-part question.
Yeah, so if you're arrested for driving while intoxicated in other states, depending on where you are, it might be driving under the influence. It might be DUI instead of DWI, or in other states, it might be OWI for operating while under the influence, or OUI, operating under the influence. Depending on what state is how they describe it. But the short answer is, in most jurisdictions, you are obligated. You can, of course, say no, but you are obligated to take what's known as a chemical test. That's the breathalyzer, or a blood test, or a urine test, or in some cases, a saliva test. If asked to do so by a police officer, they suspect you are impaired. In New York State, you don't submit to a chemical test. That's the breathalyzer, urine, blood, saliva. One has to do so by a police officer. You may be deemed by that officer to have refused to take the chemical test. And that triggers a separate administrative hearing with the Department of Motor Vehicles. See, every time you get arrested for driving while intoxicated or some sort of impaired motorist infraction in New York State, you're dealing with two separate and distinct government entities. The first is the court system, the criminal justice system. That's a state government entity. And the second one is the State Department of Motor Vehicles. So when you refuse, there's an entirely separate process that gets triggered where DMV will have a separate hearing. The Department of Motor Vehicles will have a separate hearing to determine solely the aspect of whether or not you said no to the police officer, whether you refuse to take one of those 4 tests that I described. And that alone will result in your license being revoked for a period of 1 year. And it doesn't, if you lose that separate hearing, it's a separate hearing before a separate administrative law judge in a DMV court or tribunal. These days it's being done by Zoom. Used to be in person. They may go back to in person, I'm not sure, at some point. But yeah, there's a fine and a 1 year consequence if the administrative law judge, if the DMV administrative law judge deems that you did in fact refuse. And that has absolutely nothing to do with the criminal court case. So if you beat the criminal court case, there will still be that separate administrative case in the Department of Motor Vehicles and before a Department of Motor Vehicle judge to determine whether or not you refuse to take care.
How will, let's say a DWI first, how will a DWI first impact my driving privileges?
Well, if you took the chemical test when asked to do so by a police officer, which means you've been arrested, and you take the breathalyzer, the blood test, the urine test, or in some cases the saliva test, which is a little bit less common. At your arraignment, which is your first appearance in court, which could be weeks after you did the arrest occurred in New York State, it could be days, it could be weeks. And by the way, between your arrest date and your arraignment date, you still maintain your full privileges. But when you get to the arraignment, which is the first appearance before the judge can typically temporarily suspend your operating privileges pursuant to something that's known as suspension pending prosecution. The judge will suspend your operating privileges if there is a breath analysis record, a certified copy of a breath analysis record that reflects that you blew a 0.08% or higher on the chemical test. That's the breathalyzer, the urine test, or the blood test. So if you're 0.08 or more, and they have that certified paperwork, the original copy of that paperwork, your operating privileges will be suspended temporarily. They would physically take your license at your arraignment if you have a New York driver's license. If your license is from another state, they won't physically take the license itself, but they nevertheless will suspend your operating privilege to operate or drive a motor vehicle in New York State, pending the outcome. A separate aspect of that is you can apply for a hardship privilege before that same judge that just suspended your license. And if that's a discretionary operating privilege that is issued and the determination made by that judge, and if she or he decides that you have met that quote extreme hardship unquote standard, they will allow you to drive on a limited basis to and from work and to and from medical appointments. So even though your driver's license can be suspended at your first appearance in court, your arraignment, there may be an opportunity to get a limited or somewhat restricted license. It's called a hardship privilege in New York State if you meet those elements of it, the extreme hardship. That limited license privilege is not immediately available in New York if you refuse to take the chemical test.
Oh, that's good to know then. Well, what about insurance rates? DWI first. What's going to happen there? I mean, my guess is my insurance rates are going to rise. But talk about that.
Yeah, that's a good point. That's what, that typically occurs when your case is over and if you're convicted of a DWI, or if you're convicted of anything that relates to a driving while, as it may, or an impaired, that you operated a vehicle as an impaired motorist, you potentially face the collateral consequence, that's what I call it, of higher insurance rates. And, it may be, it may be worse. Your insurance carrier may cancel you. You know what I mean? And again, it doesn't happen for everyone. It's probably happens with many. If it doesn't happen with you, you potentially dodged a bullet, and it's rare. More often than not, it does happen. It has a particularly higher consequence, for example, if you earn a living by operating a motor vehicle. If you, for example, receive a company car, if you're an Uber or, one of these drivers that works for a shared ride type platform. So yes, that can happen. There are other collateral consequences for a DWI conviction. If you're convicted, a DWI is a crime in New York State. Crime meaning a misdemeanor or felony. So depending on what you do for a living or whether or not you hold a professional license, there can be other collateral consequences. So you should discuss that with a skilled, DWI attorney or a skilled attorney that practices in criminal defense.
In New York, what are the penalties for a DWI first?
Well, the first offense, at the time as you're taping this, it's the penalties are a fine of $500 to $1,000, and up to 364 days in jail, or both. So a fine of $500 to $1,000, up to a year in jail, or 364 days in jail, or both. You can add 3 years of supervised probation. There is a mandatory New York State surcharge of $400 or $395 if you're a town or a village court. I think it's actually the other way around. So there's a separate mandatory state surcharge. DMV has its own set of penalties. So DMV has what's known as a driver responsibility assessment. That's $750 if you're convicted of a DWI or even a driving while ability impaired charge. That's $750 separate DMV fine you can pay over 3 years. There's a 6-month driver's license revocation of your driver's license. You have to attend a victims impact panel session, Mothers Against Drunk Drivers. We call it a MAD, victims impact panel. One session of that's approximately 2 hours. You have to attend that. And you have to install an ignition interlock device. And that is a device at your expense. You have to pay for its installation. You have to pay for it monthly. You have to pay for its, its calibration monthly. You have to install an ignition interlock device in your car for a period of 1 year, or up to 3 years if you're assigned to probation, at your expense. And in no event, depending on the resolution, sometimes you can get what's known as a conditional discharge in lieu of probation. That's where you basically have to stay out of trouble for a year and abide by any conditions that the judge advise you. But if you get a CD, a conditional discharge, you can make application to get it removed in 6 months if there's no penalties. But generally speaking, you got to have that ignition interlock device in your vehicle for 1 year minimally at your expense. It's typically at the time of this writing in that $125 range, roughly. That doesn't include the installation charge, and it doesn't include the monthly calibration charge. So those are the penalties. And one final thing, you can be eligible for what's known as a conditional license through DMV, depending on the circumstance. So if it's your first offense, you may be eligible for a conditional license. Even in some cases, when there's a refusal, you can get a conditional license. But if you refuse to take the chemical test, you won't have any operating privileges until the case is resolved in criminal.
What are some of the defenses for a DWI?
Well, there's a host of those. It can start off with something as, most defense attorneys will start with the stop. You know what I mean? Why will you stop? Try and work on that aspect. Was your initial stop or initial encounter by the police officer, was that a legal stop or a justified stop? We'll start with that. But, was the ingestion of alcohol voluntary? Did you in fact drink on your own, or were you just drinking soda and somebody put something in it? That's very rare that it wasn't voluntary, but there, you can have a host of defenses based on so many things, from the sublime to the ridiculous. And people, defense attorneys, have attacked the fact that you might have had mouth alcohol, meaning that you might have had something else in your mouth, soap or something. And for example, the police officer didn't allow for the adequate time period between your arrest, the time you were arrested, and the time you were exposed to taking the chemical test, the breathalyzer. It has to be a deprivation period, typically 15 or 20 minutes, where the officer watches you closely to make sure you're not putting anything in your mouth or anything, along those lines. There will be defenses put on as to what probable cause the officer had to think that you were impaired or intoxicated. That can lead to the field sobriety test, the performance of those. Skilled defense attorney will look at that closely if she or he is familiar with those tests. I'm an instructor level in those tests, like NHTSA, National Highway Traffic Safety Administration. So I take a close look at the performance of how the motorists did on those standardized field sobriety tests to see if the officer administered them properly, garbage in, garbage out, so to speak. Are there medical defenses concerning, the individual? They perform poorly because of some medical impairment, hip replacement, a knee replacement. the person's weight, the person's age. There are so many along the lines, the probably cause of it. How about the person's health? Are they a diabetic? There's just a host of areas that a still defense attorney can probe in the defense of someone who is accused of driving while intoxicated. In many instances, you have cases where the officer never saw the person operating a motor vehicle. Did he ingest alcohol after he drove or she drove? I mean, it's very fact specific. It's very person specific. My physical health is different from someone else's, and all of that comes into play. So a still defense attorney will put together a comprehensive defense strategy when looking at each impaired motorist or DUI case.
Can a DWI be expunged from my record?
Well, yes. Listen, in New York State, and no, DMV, the Department of Motor Vehicles, as I said, whenever you get arrested for DWI or DUI, it's DWI in New York State. Whenever you're arrested, you're dealing with two separate government entities. One of them is the criminal justice system. That's the state court system. Another one, separate government entity, is the State Department of Motor Vehicles. DMV is not going to expunge a DWI arrest unless instructed to do so by a court. So in New York State, there's something that just emerged. It's the time we're taping this. It's not even effective yet. It will be in November of 2024, but it was signed into law in November of 2023 approximately. It's something that's called the Clean Slate Act. So after 3 years, any misdemeanor DWI conviction or any misdemeanor or most misdemeanor convictions, period, except if they're violent or of a sexual nature, those won't be. But most misdemeanors in New York State will be wiped clean, expunged, if you will. Sealed is a better word, not expunged, but will be sealed after 3 years. And that'll be 3 years after you're done with the criminal justice system. So if you're on 3 years probation, it'll be the 3-year time period will start when your probation or your parole is over. So the criminal court system, your DWI under the Clean Slate Act, can be sealed after 3 years if it's a misdemeanor. It's 8 years if it's a felony, and that presumes you do not get into any trouble in that intervening time period, whether it's a 3-year or an 8-year period. Again, at the time of we're taping this, that will go into effect in a few months, but it's called the Clean Slate Act. And I'm probably going to end up doing a separate video on that at some point.
Well, our guest today, I use guest, that's probably not the right term. We're talking with DUI defense attorney Randall Inniss, the ex-trooper at the Inniss firm north of New York City. Absolutely. And yeah, because you serve, it's hard to, your geography is very broad, it's not like you serve Omaha, it's a very, or, whatever town, Cleveland, it's a very broad geography. And you'll find that Randall is very consultative, very good to deal with. You're also known as the ex-trooper.
Yeah, xtrooper.com is the website. My telephone number, one of them, is 877-X-Trooper. So,
ooh, yeah, that's easy to remember.
Yeah, I mean, most people remember a number like that more than someone's name. So, yeah, but listen, I welcome questions. If anyone has any questions, feel free to reach out. Excuse me. There's no, I can be difficult to get, and sometimes in court, but I welcome any inquiry that any individuals can.
Thanks a lot, Randy.
Great seeing you again, Steve. Thank you for the opportunity.